Our next topic is all about interview versus interrogation. Interview is the questioning of a person believed to possess information that is relevant to the investigation of a crime or on criminal activities. Take note that when we use interview, okay, we usually administer it to a witness or a victim. We also have cognitive interview. It is a form or technique in the conduct of interviews upon willing and cooperative witnesses, where they are given the full opportunity to narrate their accounts without intervention, interruption, and inference from the interviewer. After the narration, the subject will be subjected to direct examination and cross-examination to clarify the unexplained portion to arrive at a clear and complete picture of the testimony. Leading questions greatly helps the investigator to obtain the full and desired information. Take note that the golden rule of interview is that never conduct or let anyone conduct an interview if the interviewer has not gone to the crime scene. The questioning should be in agreement with the facts and conditions at the crime scene. The questioning will lead wayward for the interviewer who had not seen personally the crime scene, and he will not be in a position to distinguish half-truths, exaggerations, or falsehood from the answers of the person being interviewed. There are also qualities of a good interviewer. We have rapport. It is the development of intimacy between the interviewer and the interviewee. So it is the winning, or it is a way of winning the confidence of a person being interviewed in order that he will tell all the information in his possession. So the interviewer must be in respectable civilian attire because many think that uniform is intimidating. Another one, we have forceful personality, the appearance of the interviewee, and other qualities such as skills of communication techniques and the force of his language are the mainstays of the strength of his character. Next, knowledge of human behavior, the ability of the interviewer to determine the personality and intelligence of his subject. He must go down and up to the level of understanding of his particular subject or the interviewee. Fourth, we have conversational tone of voice. So his tone of voice must be conversational, not confrontational as in interrogation. Common interest. His preliminary proving questions should be aimed to establish common interest between him and the subject. Acting qualities. He must possess the qualities of an actor, salesman, and psychologist and know how to use the power of persuasion. So he must have the ability to persuade the subject. Humiliation. He must be courteous, sympathetic, and humble, or ready to ask apologies for the inconvenience of the interview. There are also reasons why witnesses refuse to talk and testify. One, we have fear of reprisal. It is always entertained by witnesses who lack the courage to face the suspect, his company, or relatives. So this is natural for witnesses who have no means to protect themselves or no influential persons to rely on. So the investigator's power of persuasion plays a vital role. Great inconvenience is another one. The ordeal of testifying in court is an inconvenience on the part of the hands to mouth and to the unemployed. Another one, we have hatred against the police. So his hatred may be due to previous bad experiences, okay, with drug members of the police organization. And bias of the witness. The witness may be an acquaintance, friend, helper, or benefactor of the suspect. Avoiding of publicity is another one. So there are witnesses who are shy and they shun public or publicity that will bring them discomfort to their ordinary or obscure way of living. We also have family restriction. Some famous and respected families preserve their reputations by instilling to their members the need for the approval of their eldest or elder on matters affecting their families. And next, bigotry. If we say bigotry, we're referring to religious or racial, tribal, or ethnic indifference. And lastly, we have the cultist indoctrination. Some cults or religious denominations exercise religious or moral influence on the decisions of witnesses to testify. It would be more apparent when the witness and the suspect belong to same cult. Common technique to convince witnesses to talk and testify. So many of these witnesses want that they will not be utilized as formal witnesses but to remain anonymous. The investigator must initially agree that the testimonies be given the shroud of confidentiality. After the full disclosure of the information, the investigator then persuades these witnesses to be utilized as formal witnesses, especially when there is a necessity of the testimonial evidence. So the power of persuasion plays a key role or a vital role. There are also stages of handling the interview. One, we have preparation. Under this, the investigator should review the facts at the crime scene and information from other sources in order that he would be ready for the questioning. A background data of the subject should be available so that he could adapt himself to the kind of approach to be employed. Next, approach. The investigator must carefully select his kind of approach, which may be a single kind, a combination of two, or the application of all the techniques. Third, we have warming up. This is being done by preliminary or exploratory questions to clear the atmosphere, promote a conducive ground for cordiality, respect, and trust of each other. Next, cognitive interview. The subject is now asked to narrate his account without interruption, intervention, or inference, meaning to say that the subject is free to talk, so there will be no follow-up questions. He will be allowed to talk whatever he wants to narrate to the investigator. There are also rules in questioning. So, one question at a time and avoid multiple, complex, and legalistic questions, and one question at a time is desired. Take note that if you will make use of legalistic questions as if you are trying to accuse the suspect or accuse somebody, so legal terms must be avoided. Use single meaning words only. Avoid implied answers. The nod of the head or any other body language as a response to the question should be avoided. So the answer must be oral, clear, explicit, and responsive to the questions. So take note, do not consider nod or anything that shows that the subject is uh, against or even he agree with this statement. He must have to answer orally. Simplicity of questions. A short, simple question at a time is required. So take note, avoid legalistic questions. Saving faces embarrassing questions on the subject on matters of exaggeration or honest errors about time, distance, and description can be avoided if the investigator will cooperate with the subject to save his space. Take note. So, avoid the embarrassing questions. And next, yes and no answers. Do not ask questions that could be answered by yes or no. Okay? So it will curtail the complete flow of information and it will lead to inaccuracy. So there must be a further explanation once you will ask question and he will say yes, you need to let the subject justify why he's answering yes. There are also types of witnesses according to their attitude. No, nothing type. These are reluctant types of witnesses. They are among the uneducated and low level of intelligence. Next, disinterested type. This is an uncooperative and indifferent subject. Their indifference should be demolished to arouse their interest or be flattered. The drunken type, the style of questioning by the investigator should be adapted to the psychology of the subject. When the drunken subject sobered, another interview will be conducted, confronting him about his disclosures while in the state of drunkenness. Written statement must be taken during his sobriety. And for suspicious type, these types of witnesses are suspicious about the motive and actions of the investigator. The barrier of the suspicions may be removed by sincere explanations or psychological pressure. Talkative type. These are witnesses who are prone to exaggerated, adding irrelevant or new matters to their narrations. The skillful investigator could prone the unnecessary matters from relevant ones. Honest witnesses. These are truthful and cooperative witnesses where the investigator could rely upon with little or no problem in handling them. Deceitful witnesses. These are liar type of witnesses. Let them lie and order them to repeat several times their narrations. They will enmesh in contradictions. Timid witnesses. They are the shy type witnesses. The approach must be friendly and reassure confidentiality of their information. 9. Boasting egoistic or egocentric witnesses. They will be good witnesses because of their ability to express their accounts of the commission of the crime. They are susceptible to adding color or importance in their role as witnesses, probably underrating the accounts of others. Refusal to talk witnesses. These are the most difficult subject to deal with, and the causes may be trauma, shock, fear, hatred, and others. For the statement analysis, all complaints and testimonies of witnesses are subjected to the crucible of truth. Utmost care must be exercised because concluding the culpability of the suspect. For complaints and testimonies, it must be reduced in writing. So complaints and testimonies shall be reduced to writing in the form of question and answers. Never use an affidavit form. Complaints and testimonies must be placed under oath before an officer authorized to administer an oath. Next topic, we have interrogation. So we all know that interrogation is one of the most difficult but most interesting phases of criminal investigation and detection. It is the confrontational battle of wits between investigator and the suspect. It is mental combat where the weapon is intelligence and the use of the art. So take note that victory in interrogation depends upon proper and effective use of the art. Interrogation is the skillful questioning of a hostile person suspecting of having committed an offense or or a person who is reluctant to make a full disclosure of information in which possession that is pertinent to the investigation. So take note that interrogation is administered against the suspect or a reluctant witness. Custodial interrogation denotes the investigation conducted by the investigator on the suspect who is under custody. The golden rule of interrogation is that make him admit something, no matter how small or trivial. So usually, the first admission will lead to another. In securing the first admission is the biggest stumbling block in dealing with top suspects. So the purposes of interrogation are the following. On the part of the suspect, it is to extract confession or admission. On the part of the uncooperative or unwilling witness, it is to extract the information he possesses. Confession versus admission. Confession is the direct acknowledgement of guilt arising from commission of a certain crime. And it is an acknowledgement by a suspect that he or she has committed the crime, and it includes an acknowledgement of the commission of all the elements of crime and the person's involvement in the commission of a certain crime. While admission, it is an acknowledgement of a fact or circumstance without accepting the guilt. So, it is also defined as an acknowledgement by the suspect of certain facts that tend to incriminate himself with respect to a particular crime, but which are not sufficiently complete to constitute a confession. Now, I will give you an example of confession. For example, sinabi ni A, nagbigay siya ng kanyang confession. So, nandun ako sa pinangyarihan ng krimen. At ako ang sumaksak kay B. So, B is the victim. For admission, example of admission, kay A, for example. So, nandun ako sa pinangyarihan ng krimen nung mga oras na namatay ang biktima. That is an example of admission. There are also kinds of confessions. We have extrajudicial confession. Take note, if we say extra judicial confession, these are made during the time that a certain suspect is under custodial investigation. While judicial confession is made by an accused in an open court or in a court. So the plea of guilt during arraignment or any stage of the proceedings where the accused changes his plea of not guilty to guilty. Take note also that we have the rights of the accused during custodial investigation, the right to remain silent, the right to have a counsel of his own choice, and if he has none, the government must provide one for him. So, mas probably, ito yung binibigay na galing sa public attorney's office. Right to be informed of the nature of the charges against him, and whatever he says may be used for against him. So, take note, class, that these rights could be validly waived in writing and with the assistance of counsel in order that the ensuing confession be admissible in evidence. So the confession must also be in writing, signed, and sworn by the accused. So we also have the techniques of interrogation. One, we have emotional appeal. So this is a technique where the investigator combining his skills in of an actor and a psychologist addresses the suspect with an emotional appeal to confess. So this is applicable to first-time offenders only, or those who are of the emotional type of characteristics displayed by nervousness or emotional disturbances. So devotees of religion may belong to this type. Next, sympathetic approach. The investigator, in his preliminary or proving question, must dig deep into the past troubles, plight, and unfortunate events in the life of the suspect. So, an offer of help, kindness, friendliness may win his cooperation. Friend- Friendliness is another one. A friendly approach coupled with the posture of sincerity may induce the suspect to confess. Next, we have the tricks and bluffs. The pretense of solid evidence against the accused. So the investigator bluffs the suspects that even if he will not confess, there is enough evidence to send him to jail. If he will confess, the investigator will see to it that his prison term will be within the range of probation. Another one is the weakest link. Among the suspects, there must be a careful selection as to who among them is the weakest link where the interrogation will begin. By tricks and bluffs, this weakest link will be told that his companions had already confessed, that his weakest link had dealt the fatal blow, or that he received the lion's share of the loot in order to intrigue him. Another one, we have drama. The weakest link used to fake pain and agony by ordering him to shout, accompanied by banging a chair on the wall to make it appear that a commotion is going on. So the other suspect in separate rooms must hear the drama before telling them that their partner had confessed. And another one, feigning contact with family members. The suspect could be tricked that the investigator had gone to the residence and the family members had supplied facts against the suspect, and the suspect's family will be dragged into the investigation if the suspect will not confess. More tricks and bluffs, depending upon the imagination of the investigator in its particular situation. So the investigator can explore or even upgrade his strategy or techniques in order to get information from the subject. The lineup, the complainant, witness, or victim is requested to point positively to the suspect who is among persons in the police lineup. So the witnesses, victims, or complainants are previously coached about the identity of the suspect. Next, reverse lineup. The suspect is placed among other persons in a line or lineup, and he is identified by several complainants and witnesses who will associate the suspect in order or in other several crimes. So this will cause the suspect to become desperate and confess only to the case under investigation to avoid from being charged with false accusation. We also have Stern approach. Pretense of physical evidence. It is the pretense of laboratory or scientific findings pointing to the subject. Another one, we have jolting. In the questioning process, the investigator selects the right moment to shout a pertinent question in an apparent righteous outrage. The suspect's nerves will break to a confession. So this is under pressure. Indifference, the presence of the suspect, the investigator will discuss and debate about the string evidence of the case that will result in the conviction of maximum penalty. So their aim is to induce the suspect to confess by conditioning his mind that he is finally cornered with no other recourse but to confess. Feigning protection and consideration, the investigator asks a series of questions appearing to the formalities with the impression that he knows the answers. That these questions are asked as matters of consideration of the rights, protection, and advantage of the suspect. Opportunity to lie. The suspect is given all the opportunities to lie, and the suspect is questioned about his personal life and family and friends and his knowledge about the commission of the crime. So this is repeated many times. The Matt and Jep or sweet and sour method. The first set of investigators must appear to be rough, mean, and dangerous. When they had finished the interrogation, the second investigator or group investigator intervenes by stopping the first set of investigators. So by being sympathetic and understanding, he begins his interrogation. If the suspect still refuses to cooperate, then the process is repeated until there is a confession. Next, removing the ethnic or cultural barrier. If the suspect is an Ilocano, he should be interrogated by an Ilocano investigator. And the same with other ethnic or cultural groups. Searching for soft spot. In every man's heart, there is always that softest spot. Those spots may be the youngest child, the wife, the mother, the brother who acted as his father, the grandmother, or the best friend. So once discovered, there must be a face-to-face meeting with that person, and that heart steel or heart of steel will melt to pieces. For additional modern techniques, we have rationalization. It is the use of reasons which are accepted to the subject that lead to the commission of the crime. Projections. It is the process of putting the blame on another person, not alone on the suspect. Minimization. It is the act of minimizing the culpability of the suspect. So the investigator convinces the suspect that a confession will reduce the offense and the penalty. And we also have the physical signs of deceptions. We have eight, all in all: sweating, color change, dry mouth, breathing, pulse, avoidance of direct eye contact. So with this, you have learned this in the previous topic. Thank you so much for watching and listening. I hope so. You have learned something today.